Perfect. So today we're going to talk about peace bonds and how to apply for one when you are seeking like some sort of restraining order, which we'll get into against somebody. That's basically what a peace bond is. So we'll get into the nitty-gritty of it all. But before we begin, Deepa is going to welcome us all as our ED and give us a little bit of a land acknowledgement as well.
Good morning, everyone. Thank you so much for joining us today. So I will start us with the land acknowledgement, and then maybe we'll, all three of us who are from the clinic will do a quick formal introduction of who we are so that you can locate us, and then we get into the content that has been prepared for the day. So I want to start by honoring the land that we are on, which has been stewarded by Indigenous people for thousands of years before colonial settlers came to this land. It is the traditional territory of Huron-Wendat, Anishinaabe, the Chippewa, the Haudenosaunee Confederacy, and most recently, the Mississaugas of the Credit River First Nations. I want to acknowledge that I live in Oakville, which is the land stewarded by the Mississaugas of the Credit River First Nation, and the clinic is located in Toronto. Ontario is covered by 46 treaties and other agreements and is home to many Indigenous nations from across Turtle Island, including Inuit and Métis. These treaties included One Dish with One Spoon and Bam Bam Belt Covenant, which are the peace agreements to deliver and live collectively with responsibility to each other and as well as to the earth. Other Indigenous nations, settlers, newcomers were invited to this land into these covenants in the spirit of respect, peace, and friendship. As a clinic, we are mindful of the broken covenants and ongoing colonization, and we strive to make things right with our little steps every day, with the land and with each other. We are all treaty people. Many of us have come here as settlers, immigrants, and newcomers in this generation or generation before. I want to acknowledge that I am myself an immigrant. We would like to also acknowledge those of us who came here forcibly, particularly as a result of transatlantic slave trade, and ongoing wars and displacements. We honor and pay tribute to ancestors of African origin descent and anyone who have been here because of forced migration. As Canadians, we must remain personally connected to our commitments to truth and reconciliation and work to bring justice to the MMIWG inquiry, as well as the findings, as well as supporting the communities and the families who have lost their loved ones across Turtle Island. With that land acknowledgement, I just want to very quickly formally introduce myself. I'm Deepa Mattu. I'm the Executive Director of the Barbara Schleifer Commemorative Clinic. I'm also a lawyer. And I have my colleagues, Shankari, who is the self-represented litigant project worker. She'll introduce herself in a second. And Calandra Cochran, who we call Callie, who is a self-represented litigant project lawyer, but she's also coordinating a number of other projects, including leading a project on criminalization of survivorship. So she has multiple roles at the clinic. And this is part of the series of the Self-Represented Litigant Project. And we are very proud to host the project here at the clinic with the help of Ontario Trillium Foundation. And over to Shankari and Callie to walk us through lovely content around a very serious issue of peace bonds. And I think it's knowledge that we all should carry with us as people who work with clients, or even as people with experiences who need to access this part of the justice system. Over to Shankari and Callie.
Yes, so I'll go first. My name is Callie. I am the self-represented litigants project lawyer. We have this project to help self-represented litigants navigate the various legal systems, including the criminal law system, which is what we're going to be presenting on today. And I'm here with my lovely colleague, Shankari, which I'll have you introduce yourself, Shankari.
Thank you, Kali. Good morning, everyone. My name is Shankari Balendra. I am the self-represented litigants project worker, and today I will be presenting about information about obtaining a peace bond. So we will walk through that, and if you have any questions at the end of the sessions, we'll be happy to answer. Thank you.
Awesome. So just so everybody is aware and we get on the right foot as we begin, the information in this presentation is for general information purposes only and is not meant to be professional or legal advice. And unfortunately, we may discuss some triggering topics. So just a contact warning for sexual harassment, sexual assaults, violence, homicide. These may come up as we talk about peace bonds. So today we're going to talk about what are peace bonds, obtaining a peace bond. Sorry, I lost my screen, just a second. I tried to make you all smaller so I could see, and then there we go. Conditions of a peace bond, legal implications of a peace bond, the role of peace bonds in Canada's legal system, and we'll briefly discuss relevant cases. So what are peace bonds? So peace bonds are protection orders that are issued by the court to prevent someone from engaging in specific behaviors that may pose a threat to the safety or well-being of others, such as harassment, threats of violence, or other forms of criminal misconduct. The goal of the peace bond is to ensure public safety and protect potential victims by legally obligating an individual to maintain good behavior. Peace bonds are typically used at the request of law enforcement or concerned individuals who believe that someone poses a risk of committing a criminal offense, but there are no reasonable grounds to believe that an offense has actually been committed. So this is proactive, it's prevention driven. When a peace bond is issued, the person subject to the bond is referred to as the respondent, and they're required to abide by certain conditions. This might include staying away from the complainant or not contacting the complainant or not going to certain locations that the complainant may be at. Now, you may have heard of restraining orders, and how do those compare to peace bonds? So just so we're clear on the difference between a restraining order and a peace bond, restraining orders are non-criminal court orders that have certain conditions, just like what you can get with a peace bond, so prohibiting contact, harassment, or annoying the other party. But these are usually made in connection with custody or separation actions in family court. And it's usually only between ex-spouses or ex-spouses and children. The restraining orders through the family court are only valid in Ontario because they're issued under the Family Law Act, which is provincially based, which is Ontario based. Versus a peace bond. A peace bond is a court order that's more broad. It requires a person to keep the peace, be of good behavior, and obey any other conditions ordered by the criminal court. And like I said, restraining orders are in family court, peace bonds are in criminal court. A peace bond can be brought against anyone. It doesn't have to be somebody you were in a relationship with. And because a peace bond is issued under the Federal Criminal Code, it is valid in every province and territory. Now, there's two types of peace bonds, just to add further confusion. One is called a Section 810 peace bond. Section 810 of the Criminal Code is where it comes from. And it is granted upon sworn information indicating the probability of the respondent to committing a criminal offense against causing harm to the complainant or their property. And then there's also a common law peace bond, which has a much broader scope of eligibility. Instead of sorry, I'm not recalling what the reasonable apprehended breach of peace is, what the common law peace bond is, the threshold for common law peace bond. But I'm not remembering off the top of my head what the threshold is for Section 18, Section 81, 810. There we go. Next, I think Shankari will take us onto how to obtain a peace bond.
Thank you very much, Kelly. So obtaining a peace bond can involve two different processes. In a way, an applicant can decide that if she or he feels that her safety is threatened, and also there is a reasonable grounds she believes that another party would cause harm to herself, her spouse or common law partner, child, or her property, can apply for a peace bond. So if someone decides that, okay, I will be affected by this person, or it's not only about physical or harassment, it could be damage to the property. And also, if you believe that your intimate photo could be sold, shared in the websites, and then if you believe that you have reasonable grounds that this could happen, you can apply for a peace bond. In the meantime, when applying for peace bond, some people, they opt to go through the police. So they take the first step as to going and making a police report. The police will listen to you, your concerns, make a police report and get your statement. And they also want to talk to witnesses or collect evidence from people who are willing to share that information. And with those evidence, you may go to a courthouse and apply for peace bond. That is one process. And then the other process is you don't need to involve police. You can go directly to a criminal court in Ontario and apply for a peace bond. So I have accompanied one client. We went to the criminal courthouse at 10 Armory Street. And so you just go directly to the court clerk office and ask for an application. And in the application, which we will come later in that, it's a sample, very simple form, but it asks for information. So the first step, as the slide shows, find a courthouse, consider the conditions you want to request. Okay, that is an important point. Like you want to mention no communication with me, my spouse or common law partner, or my child. It could be directly or indirectly. Not to have weapons and alcohol, non-prescription drugs, or also to, as Kelly has mentioned, stay away from certain locations where you reside or you work. So the application form, as I said, when you go to, you can go in person to a courthouse, it can be done electronically, or you can mail out the application as well. And next slide, please. So this is a sample of the application form. As you know, the first part asks for the name of the informant or the applicant, address, your postal code, relationship to the defendant or the complainant. And also you can include, if you go to the bottom part, the alleged incidents. So there you have to be very clear with what kind of evidence or incidents you are sharing there. And when you share an incident or a threat, you have to provide some proof as well. So it could be police reports, hospital records, any text messages, any possible messages or social media posts, or anything which you feel threatens your safety, you can include them as an evidence here. So once the application is completed, so this is where, as a self-represented litigants worker, I can support my clients who want to make this application. And as you know, clients, especially people who don't speak English, newcomers, vulnerable communities, people who have other challenges, they will feel nervous about filling out this form. But as a self-represented litigant worker, I can support the clients, just collecting information, gathering information, providing them about a brief orientation about how the application process happens. So those kind of information will give some confidence for the clients to make this application if it is needed. And once so that's the second part of the application. And so as you know, so all this application and the information with supporting documents will be referred to a justice of peace. Now, some courthouses will give this application with the appointment with Justice of Peace right away. That was the case for my client on that day. Sometime they may ask you to come for another day with an appointment. So for the question, can I get a peace bond right away within few days? The answer is no. It could take some time because you have to get an application, meet with a Justice of Peace. And once you have the meeting with Justice of Peace, Justice of Peace will review all the evidence and make a decision. This person has reasonable grounds to make this application. And then the applicant has to sign the form under oath. So again, you're saying that these are not evidence or information you are just providing about another person, but in the meantime, you are signing under oath, promising that these are all truthful. Sorry. Next slide, please. Then once the application is submitted, some courthouses, they have something called like the first hearing. It's not the peace bond hearing. So once the application is completed, sorry, I missed a step, the Justice of Peace will send summons to the defendant or the other party. And in the summons, you need to be aware that this application, copies of supporting documents will also be submitted. And once that happens, a court date will be set, and that also will be informed to the clients in the summons. So during the some courthouses have like a first court hearing and just to see if all the documents are correct. Some will have a peace bond hearing. So when a peace bond hearing happens, that happens when a defendant does not agree to the application. So someone is applying, asking for a peace bond against the defendant. If the defendant agrees, both parties come together, sign it, and then it goes from there. Then it is completed, and then the peace bond will come into effect. If the defendant does not agree to the information shared in the application, then it will go to a peace bond hearing. So in the peace bond hearing, a judge will go through all the evidence, the statements, the information provided by the application, and then some cases, so it is not required to have a lawyer or legal representation, but as we all know, it's always if you are not confident or if you are not sure about making this application, you can always get help from a lawyer or a paralegal, or you can speak to a community legal worker as well. In the meantime, if you make an application, then the other party, the defendant, will also can bring a lawyer, and they will come and give their statements if they don't agree to the peace bond. The next slide, please. So once a peace bond is made, then we also have to consider another aspect. It's about safety planning. So because the other person now knows that an application has been made, so you want to keep yourself safe at home. You need to consider about safety about your children, safety at workplace, safety when you are traveling, you have a vehicle, staying safe in public place. Not only that, it's also about emotional safety. So you can access support groups for that. And if someone is, we all know that someone going through a violence, a harassment, they need a lot of support, so they can access support groups. Staying safety at home, those are basic things like, taking care of informing the children also about the safety, giving them code words, giving them some phone numbers to call if their safety is in jeopardy. So those are some aspects. So there are very good resources available in the websites. If I can mention one, Steps to Justice has a good document about safety planning when you make an application. Coming back to the peace bond application, so signing a peace bond. So if the defendant signs the peace bond, then the peace bond comes into effect, will be effective for 12 months period. And if the defendant does not agree, and if the judge decides that this defendant and the judge will give an order for the peace bond, and also the legal implications. So signing a peace bond in Ontario, it requires the accused or the defendant to abide certain conditions and to keep the peace and good behavior. And breaching this peace bond is under Section 811 of the Criminal Code of Canada. And depending on the severity of the breach, it could end up in jail time as well, maximum of 4 years. And also, it also applies to breaching a common law peace bond as well. So once, if we can, yes. So if I could summarize, peace bonds are protection orders issued by the court to prevent a person from engaging in specific behaviors such as which may pose a threat to the safety and well-being of another person, the other person, not only that person, but child, common law partner, or spouse. And to get a peace bond, you have to have reasonable grounds that another person will hurt yourself, your intimate partner, or your child, damage your property, or share intimate image of you. So that's the reasons. And when filling out the application for peace bond and during the peace bond hearing, it is very important to make a reasonable fear, as I mentioned before, to explain why a peace bond application is made. There are sometimes questions coming up when someone signs the peace bond. Will it affect their employment or their ability to travel outside of the country? So those are, so of course there is, when someone tries, it may affect getting some employment opportunity. It may affect some travel as well. So that's why people are, don't want to sign the peace bond. But these are some questions which comes. I believe once we open the floor for questions, we will answer more such questions if you have. If you go to the next slide, Callie. So I also want to share a brief information about the Self-Represented Litigants Project, which I am part of. And this project gives support self-represented survivors facing barriers to justice by offering direct support, information, and resources for multiple legal proceedings. And so if you feel that for this, some examples could be applying for peace bond, making a simple divorce in Ontario. So those are some supports I provide. And not only that, this project offers wraparound support services for clients as well. housing, income supports, and other social and community support programs. And so those are some examples of other wraparound support services provided. So if any of you want assistance, are self-represented, need help with a legal matter, you can call our intake, email us, or visit our website. And those are the ways to contact us and get help. And also with regard to applying a peace bond. Thank you, Deepa and Kali. If I have missed anything, please add. Thank you.
I just wanted to clarify that was the difference between Section 810 and a common law peace bond is the reasonable fear piece. Thank you, Deepa, for putting that in the chat. So there needs to be reasonable fear in a Section 810 and a reasonable apprehension of, I can't remember exactly. Sorry, I'm getting flustered. The reasonable apprehended breach of peace. So the common law peace bond is much more broader than a Section 810 peace bond. However, both carry the same weight if they're breached of maximum 4 years in jail. It's just whether you have enough evidence for one or the other. Most commonly, probably you would be doing a Section 810 peace bond.
Kelly, you have another question in the chat.
Okay. Let's go ahead.
It says, are there any challenges of making application if we only know the person's identity but not their address? My opinion is that there could be a possible challenge because the process requires them to be notified. But Kelly and Shankari, what are your thoughts?
Yeah, that would be a little bit more difficult to do because they need to be notified of the application. So you need to know their address because for them to be summoned to come to court. So if you don't have the address, unfortunately, that needs to be found out before you can apply.
Correct.
And just to add to that, that this is an ongoing challenge in many conflict situations and abuse situations that we see. Even in family law, we know that sometimes when people separate and they don't have address of their ex, and that is a frequent challenge that we hear about. My personal advice on that usually to people is that speak to a lawyer, because lawyers sometimes have ways of helping you in finding last known address or doing some kind of investigation or privacy request to figure this piece out for you. So don't navigate that by yourself. Speak to either someone like Shankari or a lawyer to figure that piece.
For sure.
There's another question. Could a work or office address suffice?
I'm not positive about that. I think as long as you can prove that that they could likely be contacted at that address, then it could probably suffice. Why is the maximum length only a year and the process to extend a peace bond easier than applying for a separate one? Oh, and is the process? No, so I don't know why it's only a year, to be honest with you. It doesn't make much sense to me. A common law peace bond, though, can be for a longer period of time than Section 810. But the process for extending there is no process for extending. That's the truth of it. There's no process for extending. You have to reapply. So you have to go through the whole process again in a year if you still have reasonable fear for a Section 810 bond. And so that's why maybe a common law peace bond may be more attractive because it can be put in place for a longer period of time or indefinitely. And also restraining orders in family court are usually indefinitely as well and can be made on an emergency basis. So if it's an emergency situation, if they're you can go to a family law courthouse to, if it was a ex-spouse, go to a family law courthouse or the parent of your child. But that's kind of the difference between restraining orders and peace bonds, is that restraining orders more emergency based in family law court, and can be in place longer. A peace bond is usually shorter in nature, and involves the criminal court instead of the family court and can be brought against anyone. So if you're being stalked by someone that like you weren't in a relationship with, or you know, went on one date with someone and now they're harassing you, or someone you weren't in a relationship with is sending is threatening to send intimate pictures of you or something like that. These are options for getting a peace bond that kind of fall out of what a family law court can do with restraining orders.
Kelly, can I add something? I just wanted to say, and I think you mentioned it in one of your slides, that you don't have to wait to apply for the second peace bond. Like you don't need to wait for it to expire to apply
Yes.
for another one. So that's an important thing to remember, that if you are continuing to experience the fear, as they say, because that's what the test is, you need to you can apply for second one before your first one is expired. And I know that, you know, how Callie said that she doesn't know why it is for 12 months. I also don't know, but um, just thinking out loud, I think the intention for that must have been set up in the legislative scheme at some point, based on the fact that these are situations which are being considered as, you know, that the fear would either, you know, alleviate itself, or it would be, you know, some resolution would happen and the fear will go away eventually, and therefore they don't need to be present there forever. When I started practicing in this area of work many years ago, what we saw a lot of times was that when someone, most definitely people who are experiencing abuse from marginalized communities specifically, if they applied for peace bond instead of getting like a peace bond which was just against that person, there was a lot of experience of mutual peace bond, that they would be invited to sign a peace bond mutually, like both parties would sign it, and there would be a peace bond issued for both people. I know that sometimes it still happens, but the situation has evolved, like the education around that has improved over the years. But I think the idea of the legislation probably is that that the fear should not remain permanently, and hence the common law is more of a solution for ongoing violence.
I think as well, because of the implications of a peace bond having some implications on employment and travel, that's also why it could be that it's only a year, versus a restraining order. You can still travel. It won't affect your employment. It's not going to come up on any record check. So that's kind of the difference between the two. The restraining order is just something that can be enforced by the police. And there is also criminal consequences for breaches. But it's not the same as a peace bond in the fact that of how it can affect your employment or your ability to travel. So that could be a possible reason as well, Deepa, of why they're only for 1 year. is because they have this more implications to them.
I agree with you, Callie. I completely agree with you. I was just checking, am I muted? I agree with you. I think that most definitely makes sense. There are a couple of other curiosities. So first one is from Lara. Can I read it, Callie and Shankari? Should I
Yeah.
read it? Yeah. So this one says, please remind me if the individual/abuser has to be living in Ontario for this to be applicable. Can they live in other province? There can still be threats, harassment, and other fears.
Yes, so the peace bonds are applicable in every province and territory when you apply for one. So I would assume as well that the defendant, the abuser, can be living outside of Ontario. That doesn't have to be a requirement in order to obtain the peace bond. It might make things logistically a little bit more difficult to get one in the sense that it would have to probably all be virtual hearings and stuff like that. But I'm sure that they don't have to be living in Ontario for you to be able to apply.
The next point is a question with, I think, a bit of a scenario built in. And I don't think that either of you will be able to give a proper legal advice on this, but I can read it and then we can maybe all deliberate and think about it. So the question is, I'm curious about employed individuals who enter into peace bonds to resolve allegation of criminal harassment. Where an individual respondent has been in treatment of mental health conditions resulting from workplace trauma, and that individual is in position of higher professional standard to public, does entering into peace bond to resolve criminal matters essentially as the same some might feel would be an admission to the charge? Essentially, the respondent would not be admitting the allegation, but as a matter of fact, would strongly defend allegations, fabricated or embellished allegations with little to no evidence provided. Do some professional employments have the requirements not to have a peace bond where there is no contest of the matters before the court and they have no criminal charges? As a matter of fact, the Crown would withdraw the criminal charges given that the respondent did complete their mental health treatment. Is there a case law on the professions and peace bonds listed on CanLII? So my first take on, as I'm reading it through, is that this would require a little bit of research, and it would require, like in terms of any resources on what is listed on CanLII, and I really appreciate the question. I don't know about any professions where there can be a requirement not to have a peace bond, unless and until you're working with vulnerable populations in a particular situation and they have their own requirement for your background check, and somehow having a peace bond shows up on your record of some kind, which makes it for that particular organization with their policies for you to not to be working with them. That's the only scenario that I can think of. But yes, people do enter into peace bond to resolve allegations of all kind of situations of crime, and not only criminal harassment, but it could also be other kind of conflicts for which people enter into peace bonds. But I'm not necessarily 100% sure of some of the higher professional standard of public comment that you're making here. Maybe Callie, you want to weigh in on that? Let me percolate and read it one more time without reading it out loud.
Yeah. So definitely we should say that entering a peace bond is not the same as a criminal conviction or admission of guilt. But rather it shows the court, signifies to the court that a finding that there was a reasonable, the finding was that there was a reasonable basis to believe that that person would breach the peace. And with a peace bond as well, I should clarify that a peace bond will not appear on a criminal record check if it is complied with. If there's breaches, that's different. It may appear on a police record, which might impact your ability to obtain certain types of employment and it may also appear on a vulnerable sector check as an outstanding entry even after the peace bond expires. So that's the broader implications of a peace bond when it comes to employment.
I think the related query that is, and this is super helpful, I completely agree with you, and that the breaches should show up on record and not necessarily the peace bond itself, but the result with the booking of charges with the record of the police would be showing up differently in different kind of screenings and background checks. Is there case law on professions and peace bonds listed on CanLII? We can do some research for you and get back to you on this one if you want. I don't think any one of us would have that information handy. Callie and Shankari, am I correct in saying that? Yeah, but yeah, please do connect with us. We should have your email address, I assume, from the record of the meetings with today's meeting and webinar. But if not, then we will leave the email address for the project where you can email us later on. But thank you so much for asking the question. The next one we have is the application for common law peace bond different from section 810 peace bond? If yes, what's the criteria to apply for one and what is the difference? I think some of it has been already discussed, but maybe Callie or Shankari, you want to recap?
I'm actually not positive. It doesn't, I think there's only one peace bond application available online. So it seems to tell me that there's only one application to apply for them. So it seems that there's just the one application. I'm not sure, maybe at the first court date is where the first hearing is where it would be determined whether it's going to be a section 810 peace bond or if it's going to be a common law peace bond.
I agree with you on that there is no, it's very similar, and then there is the only no requirement is for no requirement for ongoing fear, and the police officer does not swear in information. That's the only difference, and otherwise it's pretty much the similar process. Maria has shared a link which is probably,
I referred to Maria's link because it had some more information about employment. So thank you, Mariah for providing that.
yeah.
And we knew that it would show up on a vulnerable sector check. We just forgot to mention that. And then when it comes to traveling, in theory, it shouldn't affect anything. It's just that when traveling to the States, especially, the states seem to think that peace bonds are more harsher than they actually are, that they carry more weight than they actually do. And that's where things can get bundled up is in that the US considers them more serious than we consider them. Are there some keyword searches that would help research on CanLII that might direct some research? Yeah, CanLII is actually pretty good. So I think if you were to put peace bonds employment in as keywords, you'd be able to find some case law. You would have to put them as keywords, not as the case name or something like that. But CanLII is actually pretty good for searching based off of keyword searches.
On the same issue, I think I think John is asking us this similar question related to and I totally agree with you in that second comment that you have made just now, that that professionals should be held for higher standard. And one thing which is coming from the top of my mind, like, reading your comments, is that maybe that one point of entry for your research could be to look at what is the professional standard that they are given. So that could be one of the things that you want to, maybe whatever profession you're looking for. Like, so for lawyers, for example, there is a professional standard that is set by the respective law societies that we are member of, and we are expected to abide by that. So I would say that a point of entry could also be to see, other than the pieces around peace bond and and all of those pieces, that might be another way to look at it. And thank you, Maria, again for sharing Steps to Justice resource. It's super helpful for people as they're navigating. Um,
And I put in the
yes.
chat help for Canly. They have a YouTube channel as well, which may be helpful.
Amazing. So one thing that is coming to my mind, if I may ask a question as well, is that in terms of, within the scope of the Self-Represented Litigant Project, as both of you are, reviewing the materials and working with clients, how much of this is actually possible to do without help of a lawyer? Like, how is, in your observation and the work that you are doing, is it really truly that the peace bonds are designed for clients to access it themselves without support?
Shankari, I would divert to you.
Yes, thank you. In my experience, like, to be first of all, for clients who are non-English speakers, who are new immigrants to Canada, as we all know, most of them have this fear to approach authorities, and they are not aware about a peace bond. And so this is my experience working in frontline for the past 15 years. And so giving that information to clients and telling them that there is support available to you, accompanying them to the courthouse, sitting with them while they fill out the form, helping them to gather the evidence, police report, hospital records, and all, will thus help a lot. But in my opinion, in my experience working in the front line, I would say, especially non-English speakers, newcomers to Canada, vulnerable communities, they do not have information about that.
Thank you, Shankari, and that's why a conversation like these become really important, right? Because people need to understand how to navigate, and we know within our conversation here there can be layers of complication that can be beyond you. Another, again, I just want to hear from both of you. I know we have very few minutes left, but very quickly, we earlier in the conversation and when you were delivering the materials, we talked about that the notice goes to the person, and within the context of the gender-based violence that the clinic works in, I have always found that a bit tricky, especially if it's a familial relationship within which you're trying to seek peace bond. And I want to hear from both of you, what's your observation on that? That when you're trying to protect yourself from abuse from, say, your own family member, and now there is a notice that's gone to them, and if you happen to be living in the same house, what could that do potentially to the dynamic of this family, and what are the things that maybe clients should keep in mind when they're navigating those kind of situations?
Yeah, I think for one thing, doing safety planning of your own self above, the safety that Section 810 peace bond or common law peace bond provides, I think would be really important. Unfortunately, it is a natural, not a natural, but is a step in the process that they have notice of the hearing. If it is, that is something that we fail to distinguish with a restraining order, is that there is no notice. It can be done on a ex parte basis, meaning that there's no notice. So a restraining
Right.
order in family court is if it is applicable, it could be a better avenue when there's a lot of fear of threat of harm, because of the protection of them not having notice of it. But then that is to say, though, they get notice of it eventually, obviously, because they have to abide by it. And they also get a hearing of whether they, if they disagree with it. So it just happens after the fact, after it's in place. So yeah, Shankari, if you have any tips on safety planning, that would be great.
Yeah, and as I mentioned before, applying for a peace bond is not only that one process, it has to include this aspect of safety planning, I would say. And that's an educational piece. So as a community worker, anyone, even settlement workers, frontline workers, when they have this basic information about the peace bond, I'm sure some are going to listen to this, looking at this information in our website, but they also need to make sure that they are informing and educating their clients about safety planning. That's part of the peace bond application as well.
Mhm.
Thank you so much, Shankari and Callie. I know that we are 5 minutes to the wrap up. If there are other questions, if not, then
I don't
maybe
believe there
you.
are other questions in the chat. Maybe we'll give everybody a second. Shankari, do you want to put your email in the chat? If people have further questions, they can contact us through you. If you're referring a client to us, I would encourage you to use the intake email or have them contact intake or contact intake with them, because all of Shankari's clients are directed through intake to get to her. So if it's a client referral, please go through our intake.
And if I can just very quickly add, the reason for that at the clinic is that we have a centralized system of intake, which we are very proud of, because every client receives a similar risk assessment, a similar safety planning. We triage our clients based on their risks, and we really make sure that there is a lot of consistent way of case management that happens for the clients, and hence intake is so important. So Shankari, if you don't mind just putting intake email here as well for people. It's not that we don't want people to write to Shankari. We just don't want them to write to her directly for clients, because intake process is really, really important for the experience and the assessment of the risk. I will just very quickly say thank you to both Shankari and Callie. Any event like this or any education exchange and knowledge exchange or education, public legal education session requires a whole bunch of research, presentation, drafting, and coming together, making sure everyone's time aligns for us to come together. So I really want to say thank you to both Shankari and Callie, but I also want to thank Viviana. I know that she's left the room, but she has also been super helpful. And I want to thank all of you who have attended, but maybe Callie and Shankari want to say their own thank yous as well.
Yes. Thank you, Deepa, for opening the floor and providing that great questions for us that we hadn't thought of. It's always great when you're writing up something like this, you don't think of all the possible questions. And so it's great to have more of a fulsome conversation after the presentation so that we can get to those questions that may be lingering after the presentation. And I want to thank Shankari for all the work that she does, especially the work she does with the clients. It's so important for clients to have someone to help them navigate the legal system, and her work doesn't go unnoticed or unappreciated. So thank you, Shankari.
Thank you, everyone. Thank you again for all the participants. My wish and hope someone listen to the recorded version, create some thoughts on them. Maybe they want to know more about this and share it with other clients who they work with. Thank you. And share with friends as well. Thank you very much.
Thank you. Have a good day. Bye.
Everyone.